have Kenneth D. Cruz with us for today's webinar. Kenny's an attorney, author, professor, and international copyright consultant. Much of his work has centered on copyright issues of importance to libraries, education, research, and publishing. Dr. Cruz has been a professor of law, business, and library science, and he established the nation's first university-based copyright office at Indiana University, where he also held a tenured law professorship. He resides in Los Angeles, California, and has been an invited speaker on college and university campuses and at conferences in nearly every U.S. state and on 6 continents. So, Kenny, with all of that out of the way, you can go ahead and unmute, and I'll turn things over to you.
Wow, thank you very much. Thank you for that nice introduction. Big thanks to you, Colton, and out there I know are other folks from ALA that have been important for getting this program going. Rob, Patrick, I'm sure many others, as well as those who I've worked with for many years, publishing the current edition of the book and the previous editions. So it's a real treat to be able to come out here and help ALA get the word out about copyright and where we may be going with it. And but it's also exciting to see the greetings that all of you, so many of you who have signed up for this program, and I know many others wanted in. It's just a real honor and privilege to have a bit of your time and to see your greetings, people out there from coast to coast and from other countries, and to know that you're interested, that you're willing to spend a little bit of time with me and let me talk about copyright. And I am eager to have your questions. And so we'll have time for that as well. It's going to be hard for me to follow them in the chat space and keep my concentration on other things going on. But I know that Colton's going to help me organize all that when that time is right. We're going to be talking about fair use, but as you probably know, it's pretty tough to talk about fair use without putting it in the bigger, broader context of copyright. It's hard to talk about copyright without putting it in the bigger, broader context of where we are in the world and what we're trying to accomplish, what the law is trying to accomplish, what educators are trying to accomplish, what libraries are trying to accomplish, and fair use is part of the copyright equation that is part of that enterprise. And we hope that it all keeps us going in a productive, useful, and important direction. So we're going to see this larger context. So let me move over here where I can click a button and change the slide. You know, look at this slide. I bet a few of you have seen this slide or something like it. You know, why are we talking about copyright? Why do we, educators, librarians, whatever we might be, why are we looking at copyright? Well, it sets legal rights on the and levels of legal control about the way we work with somebody's original work, whether it's our own or somebody else's. And that it has these practical consequences of granting rights and then allowing uses of those works, such as through fair use or permission or some other part of the law. There are others we'll touch upon. So, you know, why copyright? Because we need to know the rules of the road, to just use that cliche. We need to know what it is that somebody has rights to, what we can do, and what our opportunities and rights are for our own works as well as for other people's works as well. So, okay, as we step back and we look at this slide, you know, I've said things like this in other groups for quite a bit of time. I've expanded on these concepts in different ways. And you know what? I go to the next slide and we take a little interlude and we say, okay, what's the big world? What's the big picture of copyright? And yeah, it's worth a minute right now for us to take a look at what copyright does and how it's structured, because I'm confident with so many people. Do you realize we're up to 873 who've logged on? It's incredible. Of 873 individuals out there, surely some of you are coming to copyright for the first time. And so still even some of these basics are going to be new to you, and that's good. That's why you're here. So just even if, as we take a minute and think about how copyright is a set of legal rights and limitations that applies to a broad scope of works, that the way the law is constructed today, you get instant automatic protection as soon as you create that original work of authorship. And in our country, fix it, like write it down, chisel it in stone, or save it to the hard drive of your computer, that you fixed it in some tangible medium. And once you've done that, just instantly, automatically, you get a copyright legal set of legal rights that lasts for a long period of years, and that covers a broad scope of activities, much more than just making copies, making derivatives, and so on and so on. And if you violate somebody else's rights, there's a risk of penalties and infringement. But all of this survives and is functional in modern society because it's tempered by these limitations and exceptions. And so that's going to be where fair use and others, I'll touch on others, other exceptions, but where fair use comes in, it's a limitation on the rights of the copyright owner. And so there's our status quo world, and here's our upside down world. You know, I am grateful that you are here because I'm grateful that we're anywhere. This has been a hard year, hasn't it? And so we've overused this word normal. And so what is it that we can think about normal? As I back up a slide, look, there's a basic structure of the law. We could call that normal. This is the kind of structure of rights and limitations and term of years that comes to us from Congress and other sources, and tells us what the basic construct of the law is. This is, if you will, normal. And yet we're at a time where we've spent a whole year and a little bit more than a year, and it's going to be a little bit more time, with thinking about normal. And it is tough to come to normal because this is an era where our lives are disrupted, where work is destabilized. We all know we've been working from home. If we've been doing that, we're fortunate to have that option. And travel is suspended. I used to go to conferences. I haven't done that in quite a while. And families are strained. Human rights, oh my gosh, just look in the streets, just look at the voting, just look at everything. And learning, education systems are in turmoil, financially, pedagogically, and in every other way. And our constitutional standards have been challenged. They're at risk. Our international relations are frayed and in disarray. Yes, you know, who invited Kenny Downer to this program? I'm sorry to bring you all this bad news, but you know it already. Our world is a little bit upside down. And so we need to figure out, how do we get back to something? Because over the coming months, I'm going to be brave enough to say, we're going to be phasing in a new set of activities and thinking about where we go next in libraries, in education, in our home life, and in every other way. And yet, geez, let's be optimistic, or let's just get back to planet Earth and talk about certain things that are just concrete and happening. And yet, in the midst of all of these challenges and difficulties of the last year, guess what? Congress keeps making more copyright law. And so the COVID bill, I call it that, if you will, that Congress passed in the final days of the year 2020, included some rather formidable copyright provisions. My gosh. It included what's called the CASE Act. CASE stands for something. Here's what's the important label to put on it: Small Claims Court. It created added a new chapter to the Copyright Act that establishes a small claims court for copyright infringement claims that can be brought into this panel that will then review the claim, review the defenses, fair use can apply, and reach rulings. Oh my gosh, this is a delicate dance, because Congress can create the court system. It has the authority to do that. But those judges are what are called Article 3 of the Constitution. They're Article 3 activity. That's where the court system is established in the Constitution. And the Small Claims Court is part of the Copyright Office. Copyright Office is part of the Library of Congress. The Library of Congress is part of Congress. Does it even have the authority to render decisions? And so it's not really called a court, and it's not really called judges, but it is, in theory, supposed to function. And if you're looking for a job, they've just announced the openings for these members of the panel who can then become the decision makers in these, they're not even called cases, in these proceedings. Congress gave us a bundle of new law into ways to think about how parties might enforce rights. You know what they also added to it? That same bill at the end of 2020 is a whole new set of criminal penalties, probably not applicable even in the worst situation to anybody in this room listening in today, but it's really about the large-scale platforms and video streaming and creating the risk of criminal penalties for some video streaming. And within the last couple of years, there's been more. A new regime of legal provisions related to pre-1972 sound recordings. That merited an entire new chapter in my book. There's a little plug for the book. And so I used to have a chapter on music. Now I have 2 chapters related to music because the law here has grown. And this new body of law for protection of early sound recordings, which if you listen to oldies radio and you watch commercials and you go to movies, no, nobody goes to movies. You watch movies streaming at home, that you can listen, you will hear early music constantly in the use of early recordings. And this sets a new regime of legal rights that go with it. Same thing if you're in the music business, a set of licensing provisions is new. There's an exception to the public domain status of government works. If anybody out there listening, we have 910 now. If anybody out there listening is from the U.S. Naval Academy or one of the other federal military educational institutions, that there's an exception that allows for copyright protection for some of your scholarly work that's created by faculty at those institutions. And then of immediate importance to many of us listening in on this program right now is the issue of providing services and formats of works for persons who are blind or otherwise visually impaired. And so there is new law from that. On that subject. And let me just say, because I'm not going to say a whole lot in this session about international copyright law, but I will put in this point right now. The reason why, as a practical matter, the reason why Congress acted when it did within the last couple of years to expand and revise the exception of that allows us to provide materials for the needs of persons who are blind. The reason why Congress made that change is international. It's because WIPO, the World Intellectual Property Organization, WIPO, because WIPO developed a treaty that addressed this issue, and that creates some realistic political pressure on the 193 now, I think it is, member countries that are members of WIPO to create law on this issue. And so many of them have in the last couple of years, including the United States. That's just a reminder that a lot of what we do when we create law here in the US, and I could be saying this about most any other country of the world, that when we create law in the US, often one of the reasons why we're doing it and why we're doing it the way we're doing it is because of the international treaty requirements. That's a longer story. Oh, another plug. That's a chapter in the book, but maybe we'll do another webinar on that another day too. But let's pause and step back from this slide and just remind ourselves that even in an era where the world is upside down, Congress keeps creating new law. And when Congress creates law, there's something really special about it because Congress has the power to like create new appendages, whole new pieces of the law, or to make policy decisions like to up the number of years of protection for copyrighted works. And so Congress has that power to really, in little bits, in pieces, or in broad strokes, redefine or restructure the law. And then it's the courts that come in and often tell us what that law really means. Let's see if we're there. Well, here's a mixed bag. As we think about too, where we are right now after a very difficult year and where we are in the world of education and then the library services that tie into this, that we are, well, think of it this way. You know, as institutions K through 12 and colleges and universities and every other kind of educational institution has gone online to a small extent or a great extent or even exclusively, that they have depended to a great extent on the law, or if they haven't depended on it, there are parts of the law that are going to apply anyway, whether they knew it or not. And then even if they haven't done that, there are some legal issues that all of this activity is stirring up, and we just might have to shake out and deal with over the next couple of years as we move to our next concept of, oh, I'm going to use that word again, normal, whatever that may mean. So think for a moment about this vast trove that educational institutions of all types have created in the last year and have stored on servers that they control or somebody else controls, that are stored on servers, this vast trove of educational content. Because somebody has done what we're doing right now. They've said, oh my gosh, I used to teach class, I used to teach algebra and have all the students come into the classroom. And now we can't do that. So I'm going to stream it out to them at home. And that means I'm creating new content that I can post on the screen for people to see. And my school or somebody is going to hit the button that saves it and records it as well. So now it becomes part of the trove. And then multiply that by all the courses and all the days and all the months that have gone by in the past year, all of the primary, secondary colleges, universities, all of those institutions, multiply it out. And you can imagine this enormous recorded resource. And oh my gosh, we can start to tear it apart and think about it from a copyright perspective. What about those pictures and maps and sound clips and movie clips that were in that course that came from other sources? Was that fair use? Was that under another section, code section 110.2, that applies to transmissions in education? Was it there? Was it permission? Or was it with some other kind of license? Maybe the educational institution had a blanket license to allow certain uses. Or Creative Commons. I went out and found the photographs I needed, and they were with a Creative Commons license. Another very elaborate and well-constructed form of permission, in effect. And then there's the ownership. All right, we've shaken out what it is we've used from other sources, but who owns the finished work? If I'm that algebra teacher and I'm the one creating the explanations and the examples and putting them up on the board and streaming them out, do I own it? Does my employer own it? Have we transferred it to somebody? We've got some things to shake out there as well. This is going to keep a lot of us busy in different situations where maybe somebody has an interest in continuing the use of that content we created all during the past year. We've got some stuff to figure out. Now pause for a second on this slide. That almost top line, section 107, fair use. Well, there it is. There's our topic. And we're going to build on that quite a bit for almost everything in the rest of the presentation. Fair use as an exception, code section 107 of the Copyright Act, that permits the uses of somebody else's content, typical of an exception, under certain narrowly defined circumstances. A whole lot more about what those circumstances are will come up, as well as, I know many of you have been through fair use, the 4 factors, you've seen that before. However, what we're also going to do is take a look at some new decisions from the courts and figure out what that means. So I mentioned something about 4 factors. Here they are. If you were to look at the code section 107 itself and read it, it's simple language, it's very clear language, and in the middle of it, at the core of the statute, is the determination of fair use shall depend upon these 4 factors: purpose, nature, amount, and effect. What's the purpose of the use? What's the nature of the work that I'm using? A whole lot more about all this coming up. What's the amount of the work that I'm using? And what's the effect of my use on the market for that work? So let's take those 4 factors. You've probably seen this case. It's been around since 2006. I love to use it because it makes a point beautifully. And it's really proving to be a foundational case, excuse me. Especially if you look at recent cases for a variety of reasons, there's a tremendous new wave of court decisions about the use of photographs. And this case helped define the way courts would apply those 4 factors. And this is a book about the Grateful Dead, the rock music group, the Grateful Dead. And it's a thick, heavy book. It's got loads of pictures and excerpts and all kinds of content. And it has, among the many pieces of this book, about 6, maybe 7 it was, little miniature versions of rock and roll posters from the 70s with the 70s psychedelic kind of artistic look. And the question in the infringement case brought by Bill Graham Archives that own the copyrights against DK Publishing. You're probably familiar with that publishing house. They do a lot of really good work. Here comes the lawsuit against DK Publishing. DK defends, saying it's fair use, and the court agrees. And in applying the 4 factors, what the court does is it says, yeah, the purpose of the use, sure, it's a commercial book, everybody hopes to make money, but it also is a work of history, and it's there for the purpose of informing readers about the culture and history of the Grateful Dead and rock and roll. That's an important part of modern civilization. And so the court worked through those 4 factors, including that 3rd factor. What's the amount of the work used? Well, it's the whole poster. It's the whole thing. But it's in small scale and it's a low resolution reproduction. And so the court was convinced that, well, maybe the whole thing under certain circumstances is okay. And you know what? There are actually a fair number of cases that have ruled that the whole thing can be fair use. When you record a TV program off the air so you can watch it later, we have a court decision on that. And it's a recording of the whole thing. So the whole work can be an allowed quantity under the right circumstances. Let's look again at what's going on. And we're not going to dwell on these because I bet most of you have seen, read, heard something about each of these cases. That think about the fair use, not just in the isolated example of the individual picture, poster, whatever that's in a book, but now think of it on a big scale. 20 million books scanned in full by Google, fair use. HathiTrust, several million books stored and searchable and usable for disability access, among many other purposes, fair use. Lawsuit against Georgia State University, case that I had the privilege to work on. The case against Georgia State University about scanning of selected pages from books for e-reserves, at least under the right circumstances, fair use, including the need for developing policy guidance and proper implementation at the educational institution. We'll harken back to that a little bit later. But these are big cases. So fair use applies to big uses, and it applies to smaller, isolated uses as well. So what do these four factors mean? I'm just going to skip over this really briefly and say there have been efforts to create private negotiations to come up with guidelines, but this has largely been a bust. The parties that do this tend to get themselves all balled up in negotiations, and they kind of lose track of the four factors, and they start to introduce other variables. And fair use is already limited enough, and these guidelines, in order to reach agreement and get buy-in, tend to get narrower and narrower and narrower and more calculated and exacting. And that's not what fair use is supposed to do. Fair use is supposed to be flexible, meet changing, unpredictable needs. It's supposed to be variable so that the answer might be yes in this circumstance and maybe no if in slightly different circumstances. So these guidelines have been problematic, and you can rest assured they've never been law. They are absolutely not law. Because what is the law? The law is about that section 107, which allows for copies for education, research, etc. And it applies to multiple copies for classroom use, but still subject to those four factors. And we've had these cases. The last one on this list is Cambridge University Press, better known to us as the Georgia State case. And by the way, it's still going on. That trial was in 2011, and that case is still working its way up and down the court system. So stay tuned and stay informed. So let's get to something that's really totally new. Let's go through a few cases that can be helpful and instructive for all of us. First case, Triton Multimedia versus Burbank. Burbank, now you look at it closely, it says Burbank High School. Well, it really doesn't. It says Burbank, that's Burbank, California. Burbank High School Vocal Music Association. There are constitutional problems with suing a state agency like a school system. And the parties ran into that with the Georgia State case as well. So in order to avoid a lot of that, the lawsuit was brought against the Vocal Music Association, basically the parents group and the parents and the kids who were involved. It was probably a pretty tactless way to construct your lawsuit, but there it was. And the lawsuit was that Triton says, hey, we're in the business of licensing music for marching bands and performances at schools and colleges and so on. And look what you did. You put together this competitive montage of different musical works, and this is a very celebrated thing for schools to do. But Triton is saying, but we license that music, and you didn't get permission from us and pay a fee for the use of that music in your competitive musical programming. And the court said, well, maybe this is fair use. And look at those four factors. The court indeed ruled that this was part of nonprofit educational uses. And because they were taking pieces of the song and rearranging those pieces of multiple songs to create a new story that they were telling. So you can start to imagine high school kids stringing together this, working out a storyline using singing through and performing pieces of music. That is what the court called a transformative use. A transformative use is a very powerful determination. If you're going to win a case on fair use, it doesn't have to be transformative, but boy, it sure does help. Stay tuned. You're going to see more of that. So these 4 factors: the purpose of the use, nonprofit education transformative, weighs in favor of fair use. The nature of the work. These are musical works that sell well. The court said these are creative works. The tradition has largely been, although this is diminishing, but the tradition has largely been that creative works get more protection. And so that if it's creative, it tends to, the nature factor tends to weigh against fair use. But the amount, these were short clips, but sometimes they went to the main part of the work. But most of all, the court was persuaded by that first factor and by that last factor, that because it's transformative, the court wants to strongly apply fair use. And because it's transformative, a new kind of use out of that music, that's the kind of activity that doesn't pose serious market harm, the courts have been willing to conclude. So overall, even though a couple factors are kind of a close case, the overall, this, the court said, is within fair use. Let's look at another one, new one. Oh, by the way, look at this nice quotation. We are especially swayed here by the limited and transformative nature of the use and the work's nonprofit educational purpose in enhancing the student experience. Isn't that great? If you're going to win a case, you just want a judge to just see it like that. And we, because this isn't us, I trust nobody out there was part of this case. Maybe you were, but we get the benefit of reading this case. And when the question comes up, where the music teacher says, hey, can I use clips of this different music and have the students sing it as part of a program? And it's not within a license that we currently have at the school, well, you want to say to them, well, maybe it's fair use. Especially, let's have a look, you're not just singing the songs, but maybe you're putting them together into something new, like that montage. It's a transformative use. And it's not just for fun and entertainment. No, it's part of the educational experience for the students. If you can do that, you've made some big steps toward the likelihood that what you're doing is going to be seen as fair use. How about this one? Here's a brand new case: Dr. Seuss versus comic mix. And what the parties did in Dr. Seuss is they took the existing book of Oh, the Places You'll Go and recreate, I don't know what word, somebody's going to yell at me for saying recreated. But you know, the punchline is they lost the case, so why not? So they in effect recreated the Dr. Seuss book using Star Trek characters and expressions and concepts and so on. And so there are several pictures that were reprinted in the body of the case as the decision from the court. And here's an example of one, side by side. On the left, as you surely already figured out, that's original Dr. Seuss material. And then on the right, look at those Spock ears. We know what's going on here. That this is the version of the similar scene. You can see lots of similarities, but recast as a Star Trek kind of context of characters and words and so on. And the court overall said this is not fair use. Whoops, let's see, jump again, there we go. And that this is not fair use. And so the purpose of the use according to the court, was that it was not transformative. That what the court saw was not that you were necessarily taking the Dr. Seuss original and creating a new message, a new communication. That's not what you were doing, the court said. You were just largely using it as a springboard or a platform for saying much of the same spirit, but doing it through the interesting means of providing Star Trek kind of characters and setting. So that's not parody. We have a very important Supreme Court case from 1994 ruling that parody tends to weigh strongly in favor of fair use as a transformative work. But parody is something very specific. Parody is where you take the existing copyrighted work and you use it to comment on itself. That 1994 case was about the Pretty Woman song, Roy Orbison song, Pretty Woman, walking down the street. And so you've got the Roy Orbison song, and the rap group Two Live Crew then used that song, recast the lyrics and some of the guitar riffs and so on, and revised it as a critique on the sentimentality and wispy romance of the original song. So they weren't taking the song and commenting on politics in Washington. They were taking the song and using it to comment on itself. And that's parody. And the court didn't see this Star Trek Dr. Seuss book as parody. And it said also problematic was that the Dr. Seuss original is a highly creative work that tends to weigh against fair use. The amount was not just a piece here and a piece there, but it was substantial and went to the heart of the Dr. Seuss original. And because it was non-transformative, and because in some respects it was competing for the same market because it carried much of the same spirit of the Dr. Seuss original, the court said there may be real market harm that we need to recognize. And so look at this. Remember that quotation that sounded so good in the other case? Look at this. Here's what the court said. Because all of the statutory factors decisively weigh against comic mix and no countervailing copyright principles counsel otherwise, we conclude that boldly the Star Trek book did not make fair use of Go, the Dr. Seuss original. Ugh. If you're going to lose a case, that's a big loss. That just sends you home wondering what you were doing. And if you're going to win a case, if you're on the other side, boy, you want a court to see it like this. You can begin to see what's happening here too, is the way the four factors are conceptualized and articulated ends up making a big difference in how comfortable we're going to be moving forward with fair use. Here's another really, really new case from just recent months. A lawsuit by a photographer against the Metropolitan Museum of Art. Look at this great picture. I think it really is the picture, as best as I could tell. The picture used in the actual, that was the subject of the case. And that's Eddie Van Halen. And what's he doing? He's playing a guitar. The Metropolitan Museum of Art in New York City had an exhibition about art and musical instruments. And their point, the museum argued, is that we use this photograph in order simply to show the relationship between the artistic guitar that was part of the exhibition and the way it was used by the professional musician associated with that instrument. Whereas the original photograph was by the photographer was argued to be a photo showing Eddie Van Halen and the way that he looks and the way that he performs. So the argument being that the use of the photograph by the museum was not only part of its nonprofit enterprise, but it was also transformative. The museum didn't change the photograph, but what it did was it changed the objective and purpose of the photograph. It had one purpose in the hands of the original photographer, and it had a different purpose in the hands of the Metropolitan Museum. That was transformative use. Combined with the nonprofit purpose of the museum, that first factor looks pretty darn good for fair use. Yeah, the court said it's a highly creative photograph, so that weighs against fair use. And on the amount, yeah, it's the entire work. Normally that's not so favored, but the emphasis is really on the factual historical context, and the emphasis is on the museum artifact to show how the guitar is used rather than specifically to show Eddie Van Halen. And it's the effect on the market because it's transformative. Read between the lines here, everybody. Argue that it's transformative. That's going to be powerful in winning a fair use claim. Because it's transformative, therefore, the court said it's unlikely that the use is going to harm any realistic market for that original work. The power of convincing the court that you have made a transformative use. It's real, it's good, and it happens. So where are we going? I promised the word prediction in the title of this program. Where are we going? Where are we going with fair use? We're going many places, I'm going to tell you. But one thing we are doing for sure is we're going back to those 4 factors. That effort for guidelines and private interpretations and getting different organizations to buy in, that is a thing of the past. That is so 1970s, so 1990s. So we need to go back to the 4 factors, and we need to understand how we argue them creatively, and we need to also understand how somebody who sees it from the other side, we need to understand how they see it and what their argument is, not only to win a case in a lawyer sense, but so that we understand and appreciate that we're in a world where there are a lot of different points of view. Watch for the warning signals. Just like we can say, hey, if it's transformative, that's going to be pretty powerfully in favor of fair use. But by contrast, be well attuned to the fact that the courts are saying, if your use really is competing with and potentially displacing the use of the original and competing for the same market for the work, and that courts are going to be a lot more cautious about what you are doing, and therefore a little bit more hesitant about fair use. And also, as a practical implementation, when you think about the millions of ways that fair use is exercised every day all over the country, the number of cases and lawsuits is minuscule by comparison. So in terms of actually being sued, the chance is tiny. Although, I hate that lightning example, because if you get hit by lightning, it may be rare, but it sure does hurt, watch out. But you can greatly reduce your chances, and there are many reasons why, far more than we can get to in this session, if you develop a policy. Remember back several slides, and I mentioned the Georgia State case. Important in the Georgia State case was not just, what do the 4 factors mean? Let's shake it out and come to a decision. Ultimately, the court did that. But an important part of that case was that the parties were acting pursuant to a policy developed and properly implemented at the university. The court didn't dwell on what the policy said, and that was good, because different institutions are going to make different policies for various reasons. But have a policy that guides your community through fair use, answers some common questions, gives some examples of what is and is not fair use, but that all ultimately keeps you current with developments in these new cases and new laws that are allowing fair use, probably in a way that 20 or 30 years ago would not likely have survived a court ruling. So stay informed about these developments and stay flexible. Problem with a lot of those negotiated guidelines is they lock you in. You can do this much. You can do only this. And so stay flexible. And because fair use depends upon the specific facts, I know we all have 1,000 of these fair use decisions to make every day, it seems. And so we can set some rules of operating procedures and rules of thumb for certain common kind of activity, like how, certain pages and so on for reserve use. But otherwise, stay flexible to assess what you are doing in different situations. And so, do we even need a normal? Do we even need to think about normal? Maybe not, because as we come, I don't know if maybe I'm overstating this, I'm being optimistic. As we say, the ability to transition out of pandemic time is coming up. I'm optimistic enough to say that. Don't worry. I think that's a fair statement. As it's coming up, it's going to be slow. It's going to be different for everybody, which means we also need to be flexible. We need to be reflective on different circumstances. And we need to think not about a normal, because a normal implies a constant. It suggests that there is an answer, and this is the answer we're going to live by. No, I think what we're heading into is a ongoing state of steady transition. So it's not a transition into a new normal, but it's a normal that is transition. And it's a normal that's going to be made up, at least from a copyright world, if these pieces continue with us as the salient part of our thinking. It's going to be most of all a lot of fair use. As we ask ourselves 2 years from now, and we're all feeling good, and we got a lot of students meeting on campus, and we say, great, can we pull out of that treasure trove those recorded mathematics lectures and use them in a class, even though they have clips of different pictures and graphs and things from other sources? We're going to rely heavily on fair use to shake that out and sort through it. We're going to rely on Section 108. That's the code section that applies to library services. We're going to rely on 110, the provision about classroom teaching and online teaching that allows different uses under different circumstances. And don't forget the public domain. For some of our uses, the public domain is richly valuable. It might be a government work, or it might just be an old work like Happy Birthday to You that eventually enters the public domain, a great resource. And then the growth of licensed and Creative Commons materials. And then some of that new law, that stuff about pre-1972 sound recordings. If you want to use early rock and roll in some kind of project that you're using, well, that sound recording is subject to new law. But here's the really good news. That new law has a number of different exceptions, new exceptions for non-commercial uses, and it protects the existence of fair use and Section 108 and other exceptions being used in connection with pre-1972 sound recordings. It's kind of a nutty law in some respects, but when you get into the substance of it, it's not bad. It actually has a lot of good stuff. And then just got to throw this in, that small claims court. Boy, I'm not sure what it's going to bring. And I think it's going to be a pesky place to fight over, a photograph on a website, but not a whole lot more than that. And a lot of libraries are in fact automatically excluded from some of it, and at the choice of libraries, I should say. And other institutions are going to opt out of cases that may be filed against it. But we'll have to save that for another session. So that said, I thank you. I thank you very, very much. And it's been a pleasure being here with you. And I know we have a little bit of time, and I trust there have been a lot of questions. And I'm going to hand this over to Colton or whoever else is listening to relay some questions. Thank
Yeah,
you.
thanks so much, Kenny. As you can imagine, we just got a few questions, maybe one or two or a few dozen. So I'm gonna try and pick out the questions that seem like they'll be most applicable to the widest number of people, since we've had a lot of questions come in. Someone asked what some good resources are to keep up with copyright cases and libraries. I've seen a bunch of people posting links into the chat for that, so thanks to all of you. And the recording will also include a playback of the chat, so you'll have that as well. I just wanted to mention that out on the gate. Kenny, for you, it seems that many court decisions focus more on factors 1, purpose, and 4, effect on the market for fair use. Is that the case?
It is, and it's increasingly the case. Back in 1985, there was a 1984. There was a U.S. Supreme Court decision that said that the fourth factor is the most important factor. The passage of time has really proven that that's not true. If I can give you a short answer, I'm going to say this. What's the most important factor? It's the factor where the evidence that you have in your situation is the most powerful and most persuasive. Realistically, what does that mean? It means it's either the first or the fourth. It's the fourth. The reason why the court was quick to say way back, the Supreme Court was quick to say that the fourth is the most important, was because there was evidence in that particular case of a real lost deal that was canceled. Money was not paid because of the use that scooped and preempted the deal that the parties wanted to make. So there was a cash value of the copyright that was lost, and there was the evidence of that. The court didn't like that. That weighed very heavily, I think, in the court's thinking. On the other hand, what was really happened, and what the Supreme Court, I think, gets credit for this too, is 10 years later, in that Pretty Woman case in 1994, they really shifted the evidence to the first factor. But once again, it's going to be really important if the facts are right. The fourth factor was important when the facts were powerful. In the Pretty Woman case, the first factor was important because the facts pointed to criticism, parody, those things that are favored by fair use. And that once the first factor was leaning in favor of fair use, there's kind of a ripple effect through the cases. And then what also happened, starting in that case in 94, was the Supreme Court in 94 looked at that second factor, the nature of the work, and said, you know what, this may not be very important at all. Because if we're talking about, in that case, parody of a work, the nature of the original work of which you are making the parody doesn't matter. It doesn't matter if it's a boring work. It doesn't matter if it's an artistic work. It doesn't matter what it is. So the nature of the work is not important. And courts have picked up on that. And you'll see a lot of cases for various rationale with the court concluding that the second factor just doesn't mean much here. And they move on to the third factor. So you're right. In the end, it's that first factor and the fourth factor that make the biggest difference.
All right, thank you so much, Kenny. And we're getting a lot of specific questions in the chat here, folks. We've only got about 5 minutes left, so I'm going to try and cover some of the more general questions, so we can hopefully address more concerns here. So, Kenny, we've gotten a lot of questions regarding copyright and online story times. So,
oh, great.
Yeah, I'm guessing that's something you have talked about before.
It is, and I'm guessing maybe we're talking about kids, and we're probably talking about public libraries. Um, let's talk about it. Let's talk about it. First, I know that at the beginning of COVID time a year ago, there was some trouble stirred up over this use, and I know that a bunch of publishers, let's give them credit, that a bunch of publishers stepped up quickly and said, let me make clear, you have please, in these extraordinary circumstances, go ahead and hold story time. So if you just do some online searching for that kind of activity and publishers and so on, you'll probably find some press releases, and I think a few people put lists together online showing, which publishers are being helpful about all this. And that's great. Realistically, that's kind of a license, that's a permission that they're giving you. Eventually, it'll kind of wear out its welcome. The publishers will say, "Oh, what have we done here?" Or yeah, we meant it and we still mean it, but only because of the pandemic time and circumstances. But we expect you to roll that back when we come out from under this rock that we're under. So be ready for that kind of transition. If you were to apply fair use, I think you can do pretty well. If you're talking about your limited audience, reaching a kid directly related to the activities and the mission of a public library, do this. Mix in a few things, make it a transformative use. Have some of your colleagues and kids come over, get their permission before putting them online, and have them come over and act out roles. And the third factor, what's the amount? Just use only a portion of the book and not the whole thing. Or the effect on the market, hold the book up to the screen, make sure everybody sees it, give them a couple of links out to retailers or the publisher where they can go buy a copy, and encourage, overtly, explicitly encourage people to buy a copy if they like that book. You're not being a commercial. You're promoting good things, just like a book reviewer would. And so that's okay. I think if you can adjust what you're doing to fit into fair use, even under non-pandemic time. I almost said normal, under non-pandemic time. I hope that helps.
All right, thanks so much, Kenny. And we are at the top of the hour, so we're unfortunately out of time, but we do appreciate all of you asking so many questions. Kenny, is there anything else you want to say before we go ahead and close out?
Well, my goodness, I want to thank everybody again. This has been a great privilege, and I'm glad there are a lot of questions. I have not been able to follow them, sorry to say, so I'm going to look forward to seeing them. But hey, maybe what we need to do is run another program and just have a great big Q&A time. So we'll figure that out in the future too.
All right, everyone. Thanks for joining us. Take care, and I hope everyone has a wonderful weekend. Bye, Kenny.
Bye-bye. Thank you.